Welcome to Class 4 of the Mr. Cannabis Law coursework. Today we're going to be talking about marijuana transactions. So in the previous classes, we went through some of the licensing requirements, and we also went through some hemp contracts, right? And we talked about that marijuana, federally illegal in the US, whereas hemp is federally legal. So very different considerations that you'll need to keep in mind when you're dealing with marijuana transactions, which is what we're going to be dealing with today. So some of these main issues you're going to be dealing with, the attorneys that should be interested in this course are really M&A attorneys, corporate attorneys, tax attorneys, but also what you should also be interested in is if you're doing licensing work, you need to understand some of the ownership issues within these states. So you should have a good understanding on how these deals have to be structured. So really quick, we're going to go over some of the key concepts we'll be going over today. So to start with marijuana, we already know it's federally illegal in the US. However, it's legal in Canada, and this is very important to keep in mind because a lot of these transactions now are dealing with some Canadian companies that are potentially merging or acquiring some of these US companies. So you really need to keep in mind that it's legal in Canada, however, it's federally illegal in the US. There's residency requirements in certain states, and we're going to go over some of the issues that causes. Also, raising capital in the cannabis space. Very complicated, whether you're raising it from a private perspective or looking to go public. And the main reason for that is that really because it's federally illegal, and also some of the state compliance requirements with ownership and change of control also create some complications. And then from an M&A perspective, really M&A attorneys are key in this industry, but it's important not only to have a background in M&A, but you really also need to understand the cannabis laws within the states that are being impacted by the particular transaction. So lots of exciting stuff we're going to be going over today. So the first thing we're going to jump into is residency. So several states have certain residency requirements in order to have a marijuana license. So if you're applying for a marijuana license, or if you're representing a client that's buying a company that owns a marijuana license in a particular state, you need to be very familiar with what the residency requirement is in that particular state. So for example, a state may say that in order to own a license within this state, you need to be a resident for 5 years within that state. Now, there's several reasons to do this, right? The states really, they want to protect their citizens. This is a brand new industry, and the states want to keep out some of these other guys that are in it. So it's kind of a protectionist thing, right? The states want to really provide this economic opportunity for their own citizens, but also the Cole Memo and the Bank Secrecy Act, which we talked about in previous classes, has certain enforcement priorities, and one of those enforcement priorities is about cannabis being diverted to non-legal states or non-legal markets. So not only is there a protectionist reason for states to do this, but there's also certain federal enforcement requirements that kind of give the states some justification. However, residency requirements have been knocked down by the Dormant Commerce Clause. So what we're seeing is a lot of states' residency requirements is actually being challenged in court at a state level. Now, the US Supreme Court hasn't ruled specifically on any cannabis residency issues, but the US Supreme Court has ruled in other industries such as alcohol industries that these residency requirements are not allowed. So what we're seeing is even in states that specifically state in their statute that residency is required, some of the agencies are rolling that back and saying that it would violate the Dormant Commerce Clause, and therefore they're not enforcing those residency requirements. Also, that residency requirement also causes challenges for raising capital and for structuring your deal. So if you're let's say in Illinois, and they have a residency requirement within Illinois, and you want to go out and raise $10 million, but the ownership needs to be restricted to Illinois' residents, that obviously reduces your total market to try to raise this capital. So these residency requirements really reduce access to capital. Another thing that these residency requirements do is they make deal structure extremely complicated. Let's say you wanted to sell your company. You spent years building your cannabis company, you're a resident of this respective state and you want to sell, and an out-of-state person is giving you the highest price, but you have a residency requirement within your state, so you can't sell to that highest buyer. It becomes very, very complicated. So residency requirements, it's very, very important. If you're dealing with a transaction with this space, if it's an M&A transaction, and now there's multi-state operators, a lot of different parties that are involved in these transactions with different subsidiaries, and some of these subsidiaries have licenses in this state and licenses in this state. You need to make sure you're very familiar with all of those states' laws and understand the ownership and the residency requirements. So moving on to the next slide, what we're going to cover is we're going to talk about raising funds in this industry. We already kind of talked about raising funds, but raising funds is very, very complicated in the cannabis industry for a variety of reasons. Number one, it's federally illegal. So things like listing on the New York Stock Exchange and the NASDAQ, very, very complicated. Also, like we mentioned, these state laws make it very difficult to raise capital. So we have a few different options within the cannabis industry, right? These are pretty much the options in most industries. They just have different complications when dealing with the cannabis company. So your first option is to raise capital from a private perspective, right? And that's how a lot of the capital is being raised right now. You can't really go to big institutions. Banks are not lending the capital. So what happens, they're not lending it because it's federally illegal, like we've discussed. So you try to raise it private. So obviously, if you're a very wealthy person, you could self-finance, right? If you have millions upon millions of dollars, which is that's what it takes to really make most of these companies operational, you could self-finance it. Your other option is to go with a VC fund, venture capital fund, or some other platform that's specifically tailored for the cannabis space. Most conventional and institutional lenders will not lend to you. So really, the private side becomes very complicated, and there's specific venture capital funds that are set up specifically to either lend or buy equity in some of these companies. There's also the New York Stock Exchange and the NASDAQ. Now that is kind of the gold standard of what companies eventually want to do when they're raising capital. They want to get on the New York Stock Exchange, or they want to get on the NASDAQ. Now, what's complicated here is that New York Stock Exchange and NASDAQ are in the US, and marijuana is federally illegal. So if you are operating a federally illegal business, you cannot list on the New York Stock Exchange and you cannot list on the NASDAQ. So what you see, the cannabis companies you see that are listing on the New York Stock Exchange and the NASDAQ, you're going to see Canadian companies, right? Because it's legal in Canada. So Canadian companies can actually list on the New York Stock Exchange and the NASDAQ. You're also going to see biotech companies. If you are going through drug development and you're getting approval by the DEA and the FDA, federal agencies to research these compounds, to take them through proper drug development, you're operating a legal business, so you are able to list on the New York Stock Exchange or the NASDAQ. This is where we're seeing a lot of the psychedelic companies falling into this category. Right now, the psychedelic industry mainly is composed of psychedelic biotech companies, companies that are looking to take psychedelic compounds through drug development through the normal legal federal pathways, which would be FDA, DEA approvals. So, for example, we just had a company, Atai, just yesterday actually list on the NASDAQ, and Atai is basically a psychedelic biotech company, and their listing was over $2 billion for their market cap. So these psychedelic companies on the biotech side are now seeking to get into the New York Stock Exchange and the NASDAQ. Two other companies in the psychedelic space, Compass Pathway and MindMed, are also already on the NASDAQ. So as long as you're operating a legal business, you could list on the New York Stock Exchange or the NASDAQ. Now, since a lot of these companies in the US are actually operating illegally from a federal perspective, but legally from a state perspective, they will go on the CSE. So you're seeing a tremendous amount of these marijuana companies listing on the CSE. This is mainly US companies that are not able to get on the New York Stock Exchange, on the NASDAQ. So there's a few things that you need to be aware of when you're doing these things. So for example, when you list, you're either going to list as a foreign private issuer, or you're going to list as a U.S. domestic issuer. Now, the coursework goes into both of these terms in great detail, and the coursework really outlines the entire process of all of these different capital raising ways to do it. But I'm not going to do that in this course. Right now, we're just trying to hit the high points, but I definitely encourage you to go back to your coursework and go through some of the information relating to this. And then finally on the CSE, what you're going to find is that companies, some of them are doing IPOs, but a lot of them are doing RTOs. And the coursework goes into great detail on how you structure an RTO and what an RTO is. But essentially an RTO is a lot quicker and easier than an IPO. It's essentially there's going to be a shell company already set up on the Canadian Stock Exchange, and basically there's just a transfer of shares from the shell company to the actual cannabis company, so you don't have to deal with some of the registration and the listing and the filing requirements that are required for an IPO. And finally, your last option is essentially an OTC, over-the-counter listing, and really we go through that in great detail. This is probably the easiest, but it also gives you the least amount of access to capital. So those are kind of the overall things that you need to be aware of when you're raising capital, but all of that flows into the following slide, mergers and acquisitions. So on the mergers and acquisitions side, what we have right here is you have to take into consideration all the things we just discussed. All the stuff that we just talked about becomes very, very important when it comes to mergers and acquisitions. So you have ownership issues. So there's state and local approval you need to be aware of when you're doing any M&A transaction. So if you're a company in one state looking to acquire a company that owns a license in another state, most of the time you're going to have to get state approval, and in some instances you'll also have to get local approval. There's also criminal background checks that you're going to have to go through. There's residency requirements, which we just discussed. So if you are a company in Illinois and you're trying to buy a company in another state that requires that 51% of the ownership is from a resident, you're not really going to be able to buy more than 49% ownership within that company. So you need to keep those residency requirements in mind as you're structuring that transaction. Similarly, there's certain requirements in a lot of these states for social equity ownership. So if you're granted, and we talked about in previous classes what social equity is all about, but just as a reminder, a lot of these states, what they're doing is they're putting out laws to benefit people that have been disproportionately impacted by the war on drugs. So if you apply for a license as a social equity applicant and you get a license as a social equity applicant, that generally will mean you're at least 51% owned and managed and controlled by a social equity applicant. If that social equity applicant then wants to sell his license to someone who's not a social equity applicant, there's a lot of different hurdles and a lot of different challenges. For example, Illinois has certain requirements that if a social equity applicant is transferring their license to a non-social equity applicant, essentially there's all these requirements, but at the essence of what it is essentially all the benefits that social equity applicant received will have to be paid back by the new owner. So for example, a social equity applicant in Illinois pays less application fees when they apply in Illinois. So that discount would have to be paid back by that new owner. Similarly, we have beneficial ownership issues. We have the assumption of liability that becomes an issue. We have bankruptcy issues. There's also financing issues, right? Because the valuations of these companies are very, very challenging. How do you value a company that is really subject to regulations that could change on a whim? So when you're dealing with an M&A transaction, figuring out that valuation becomes very, very challenging and oftentimes very much arbitrary. One of the Florida licenses just recently sold for $50 million, just the piece of paper. No operations, just the piece of paper. So how do you value a piece of paper that allows you to operate a vertically integrated company within Florida? It's kind of just totally subjective. It's whatever someone is willing to pay for it, and someone was willing to pay $50 million. So valuations become very, very challenging. And guess what? The Florida Supreme Court, after the sale of that, the Florida Supreme Court in Florida ruled on a case that actually impacts the value of that license. So, there's so many changes within this industry, and it's very, very hard to nail down valuation. There's also regulatory issues. So state laws change through the legislator. Local municipalities may place restrictions on marijuana businesses. And there's also litigation, like I just mentioned, the Florida-grown case in Florida. There's litigation that might change the whole structure of the deal that you're dealing with. There's also some challenges with the antitrust division. When you're doing an M&A transaction of a particular size, the antitrust division of the DOJ may look into your transaction. And what just came out recently is that the antitrust division of the DOJ was actually really looking into cannabis M&A deals way more than any other industry, and they came under extreme scrutiny for that. But their logic there was that they needed to do that due diligence because it's federally illegal, and it was very, very complicated. But as a result, if you're doing an M&A transaction in this industry and the antitrust division of the DOJ is requesting all this documentation, all these meetings, all this contact, and you got to continuously pay attorneys for all this time, a client is going to be paying hundreds of thousands of additional dollars just because they're a cannabis company. So these deals become way, way, way more expensive for these marijuana companies to pay attorneys. On the attorney side, obviously, that's not always a bad thing because the attorneys are the ones who are generally the quarterbacks here, but it becomes very challenging. The other thing I want to talk about is the due diligence that's required on an M&A deal. Very different than most industries. So the due diligence is really on federal enforcement priorities. We talked about the Cole memo and the BSA. There's certain priorities. You want to make sure that the company that's being acquired doesn't implicate any of those enforcement priorities. You're also going to want to make sure they're compliant with their state requirements. Very important, right? The state and the municipalities might have certain requirements. You don't want to be in a position where you acquire a company and you find out that they're out of compliance with their state or local requirements. And finally, tax compliance. We're going to go through in a separate class the issues with 280E. I will tell you, a lot of these marijuana companies are not set up properly to deal with the 280E issue, and I've seen it become an issue after a company gets acquired, that they find out that there's all this tax liability that they didn't really know about. So very, very important that on the diligence side, you're doing all that stuff. So going to the next slide, we're gonna go over the do's and don'ts of what we just learned today. So do use this information to understand the variety of ways that a marijuana owner's residency can be an issue to better prepare you to avoid any residency issues in a marijuana transaction. As an attorney, you're going to be having some of these very complex M&A deals with entities that own licenses in multiple states. Very, very important you look at the residency stuff that's involved in there and the ownership requirements as well, whether it be social equity or anything like that. Also realize that marijuana C Corps offer the greatest corporate structure to raise funds. I've been in several situations where these companies start off as LLCs, they raise several rounds, then all of a sudden they want to go public, and it becomes extremely complicated because when you're going public, you're most likely going to want to be a C Corp. So much easier if your plan is to raise capital and even potentially go public, you're probably going to want to start off as a C Corp, but you should definitely, as an attorney, definitely make sure, if you're an M&A attorney, you're working with the tax partner to make sure that you're properly structuring this transaction on the front end. Also, use this information to spot problems in an M&A transaction. And really, you're going to be spotting some of the diligence issues, some of the residency requirements, social equities, the change in control. Generally, we talked about it. Some of these states require certain things to happen when you're changing control, and usually the state is going to have to actually approve that change of control. So when you do your transaction, when you go from letters of intent to definitive agreements, you want to make sure that all of that is contingent on these states approving it. So don't enter into any marijuana transaction without carefully considering the state's residency requirements and also the social equity requirements if you're acquiring a company that has a social equity license. Don't forget the financing in the marijuana industry is incredibly difficult. So if you're advising a client that's just starting off in this industry, make sure you really have a good plan moving forward on how that company is going to be financed. And don't enter into a marijuana M&A transaction without considering all the pitfalls that we discussed today. There are so many different pieces that could be very, very complicated in an M&A transaction, and it really requires multidisciplinary lawyers working on an M&A deal, from M&A people to the tax people, corporate structuring. Maybe you pull in someone who is very specific to cannabis law. That's how I get pulled into some of these transactions. Some of the bigger firms will be doing a big M&A transaction. These firms are unbelievable at M&A, but they need someone to do the diligence and to help make sure it's being structured in such a way to account for all these cannabis complications. So really appreciate you taking the time to watch this class. We went over a lot of stuff. Marijuana transactions are not simple. They're very, very complicated. I highly recommend you dig really deep into the coursework, because the coursework goes through a lot of the details, and it also identifies some of the different companies that are already listed on the New York Stock Exchange or the CSE, and it really goes through what these whole processes look like. So thank you for attending today, and I look forward to seeing you for the next class.